tuned in to the Andrew Lawton Show.
I want to talk about one case, which is that of J.N., who is hoping to get the Supreme Court to affirm her right as a parent to stand up for what she thinks is in the best interests of the family. The lawyer for this case, which has details on helpamom.ca, is from the Acacia Group, and that is Lia Milousis. Lia, thank you for coming on today. Good to speak to you.
Thanks for having me, Andrew.
So I've tried to give a bit of a primer there, and obviously I know you can't identify your client by name here, but explain to me what led us here. What's actually at hand?
Yeah, so maybe just stepping back, there was a breakdown of the marriage. There are 3 children involved. And at the time, so this litigation has gone on for 8 years. I've not been involved in that. Neither has my colleague who is helping me with this case. So there's been this messy litigation, and ultimately the father and the mother came to minutes of settlement, and they were able to resolve every issue except the question of vaccinating the children. And not all 3 of the children, just the younger 2. The eldest child was 14 years old at the time of the minutes of settlement, and they concluded that he was old enough to be able to decide on his own whether he would like the vaccine or not. He ultimately chose to get the vaccine. Both parents were supportive of that decision. But with the younger 2 children, who are now their ages are about 13 and 11, if I'm correct there. And so now the issue was, well, what about the younger children? And there was this fight over whether they should be vaccinated. Now, it's important to understand that these children didn't want to be vaccinated. And so even though they are younger than their older brother, they indicated their preferences and their views. And the father's position is that that's essentially, their views are the results of the mother and shouldn't be respected, and that they should receive this vaccine regardless. And the mother's position isn't that she's against the vaccine per se. She would just like some additional information, some additional time. And she, in particular, is wanting to respect the views of the children, who are now very close to the age of their older brother when he was old enough, in the view of both parents, to make this decision. So that's kind of what led us here. And as you'll be aware, Andrew, there was a lower court decision that resulted in the mother being awarded what's called decision making. And so she was given decision making over the question of COVID vaccines. Just, to be clear, the children reside with her primarily. She'll, have decision making for most matters. And so now she was awarded by the motion judge the ability to make decision regarding COVID vaccines. And then this was appealed to the Ontario Court of Appeal, and they overturned the decision. And not only did they overturn the decision, and typically, it would get sent back to trial for another decision from a motion judge, but they actually implemented their own order, and they awarded decision-making to the father. There were a number of reasons of that, which I'm happy to go into, but that's kind of, that's where we're at, and that's a little bit of the background of the case.
So let's just, talk about the vaccination aspect here, because the mechanics of getting vaccinated is that you can't, as I understand it, be devaccinated. So once it's been done, it's done, which means I think the stakes are higher if you side, in this case, with the father than with the mother. But I am sympathetic to the argument that younger kids are probably getting a lot of their influence on this from their mother. I think kids are smart, and kids can make up their own minds, but kids are also products of their surrounding, and kids will be products of their mothers. I'll characterize it as vaccine hesitancy. So how does she answer to that? How does the mother articulate where the children got their aversion to the vaccine from?
Yeah, so there are a few things I would say to answer that question, Andrew. First of all, there was what's called a view of the child report, or 2 views of the child reports that were done for all 3 children. And that wasn't done specifically regarding the question of the vaccine, but one of the issues touched on in the second views of the child report was about the question of vaccines. And it was in that case, in that report, that the social worker who did the different interviews concluded, these children, these are the views that they have. They seem consistent. The social worker didn't flag any type of influence. Now, I think, obviously children are going to hear both sides. And so I think it's interesting that, with the elder child, there wasn't concern that, he was just going along with what his father wanted. Both parents respected the child's decision. And in that case, it was the decision to get the vaccine. But then in the younger, with the younger two, despite the fact that they are being exposed to the same kind of voices on both sides, both parents have, the record says that both parents have spoken to the children about this issue. The children are very clear about the positions of the parents. And the younger two children have decided that they don't want the vaccine at this point in time. Now, I mean, the trial judge concluded that there wasn't evidence that the views of the children were only a product of the mother. So that was a factual finding. But it's also important to understand, and there is case law, and we referenced this case law in our motion to stay, because we put forward a motion to stay the order of the ONCA, the Ontario Court of Appeal. And one of the things that has been demonstrated in some of the case law is that even if the views of the children are misguided, are only the result of a parent, if they're sincerely held, if these children really are this opposed, then moving forward with, in this case, a medical treatment that cannot be reversed is going to have a pretty severe impact on them, particularly when the person kind of moving that forward is going to be their father. There are going to be some serious ramifications there. And it's important that people understand, obviously, when it's the COVID vaccine issue, there are a lot of emotions and perspectives that come to play, but really this is not a question about the vaccine, whether it's good or bad, whether children should get it or not. In a case like this, a family law case, the only question that the court is supposed to look at with regard to a access or parenting decision-making order is the question of what is in the best interest of these specific children, not children generally, not people generally, these children. And so you have to think not just about, who gave these children these views, which according to the trial court, it wasn't clear on the record that it was just the result of the mother. But even if it was, you need to think about how moving forward with a forced vaccine for these children will impact them and impact their relationship with both of their parents. And I think that's something that the Ontario Court of Appeal didn't consider properly.
Let me drill down further into that best interest of the child bit, because one question you've raised in your commentary on this case is about accepting, or should a judge be able to accept a government statement on an irreversible medical intervention as fact? So how does the government's position factor into this case?
Yeah, so this from in terms of how we speak about it in layman's terms, obviously we're thinking about the children, the parents, the vaccine, that's what this is about. But from a legal perspective, this case rests on something called judicial notice. And to kind of fast track and explain this evidentiary concept, the idea is that in a case, the judge has the option, it's a discretionary option, to take what's called judicial notice of a fact. And that's done in cases where the fact is so evident, so obvious that, reasonable people wouldn't disagree about this. So for example, applying that here, a judge could take judicial notice, and many judges have, of the fact that the COVID pandemic happened, that COVID exists. There'll be some people, I imagine, who dispute whether you want to call it COVID or whatever, but the reality is that we know there's been a pandemic, we know people have been affected, that is a fact. Now, judicial notice cannot be taken of what's called expert opinion. So once you start getting into the question of not just facts, but what ought to happen, or maybe what the ideal treatment would be for a child, like that's where you start getting much further into the realm of expert opinion. So that's the important thing to understand about judicial notice. And again, it's just discretionary. So in this case, there have been cases across the country regarding vaccines and children and what's best for the children. So in this specific case, the trial judge decided not to take judicial notice of the government statements that had been put forward by the father. Both parents brought different evidence. They both brought what's called, internet downloads. They kind of downloaded stuff off the internet and put it before the court. And the trial judge concluded that he wasn't going to take judicial notice of the government statements because the approval of the vaccine by Health Canada, he said, didn't translate to it automatically being in the best interest of these children. So yeah, I mean, the government approved the vaccine, and that is a fact. But the question of whether it's now by default safe and effective, and not just safe and effective, but in the best interest of these children, is a separate one. Now, the courts have been taking very different views on this, and this is one of the reasons we've appealed it to the Supreme Court, because we really think we need some insight into how to sort through this very messy area of law. Because basically, some courts have said, COVID exists, vaccines are generally good, and that's as far as they go. Some have gone a step further and saying, you know what, the government has said that this is a safe procedure, they've approved it, so we're going to conclude without getting any evidence before us that, that this vaccine is safe and effective. And then others have gone even a further step and said not only is the vaccine safe and effective, but it is in the best interest of children generally. And the real issue with that, Andrew, is that the best interest of the child analysis is not about what's in the best interest for children generally, but about these specific children. And so while I don't think, the courts are trying to kind of undermine, what's best for children, and while I don't think the government intended for their statements to be used this way, what's kind of happened with the clash of judicial notice and, the issue of the vaccines is we've now had kind of government statements almost substituting in a decision when you think about whether a child should get a vaccine or not. And basically what the Ontario Court of Appeal said is that when a question like this arises and one parent would like the children to get a procedure that has, or like a vaccine that has been approved by the government, it's basically now the onus, the burden of proof is on the parent who doesn't want that procedure to go forward to prove why it's not fair. And that's a huge evidentiary burden for in this case a self-represented litigant to bear. And it's also, it really undermines the best interest of the child analysis, which again is a hyper individualized, laser focused analysis about what's good for these children, not what might generally be safe and effective.
Well, and I think that's an important point here because, obviously we accept that adults have the right in some ways to do things that may not be in their own best interest. We accept that adults are human beings. They can make mistakes. Maybe it will have a risk to it, and adults can calculate that risk. And we also accept that adults are the primary caregivers and decision makers for children who don't legally have the ability to make that decision. And I think the gap between those two things is a little bit perplexing to people because on one hand, we don't want to say that adults have the right to harm children. But on the other hand, we don't want or shouldn't want, certainly I don't want, and people that view and watch and listen to this show don't want government stepping in to make these decisions for children. And I think that what I'm struggling with here is that you have two parents that are equally passionate about something, and I'm assuming probably in good faith, each of them believes that what they are oriented towards is in the best interest of the children. So assuming this goes on, even further till it gets to the Supreme Court, are we starting from scratch every time a case like this comes up? Or is this, in your view, a precedent-setting case?
This could be a precedent-setting case. I mean, the process is that, we don't by default get to go to the Supreme Court. We have to ask permission. We have to ask for leave to appeal. So that's what we've done. So we'll be waiting for that decision. That's where things are at right now. But I do think it could be precedent setting. And I think it's important because there, like I said, there have been conflicting decisions across the country, not just at the trial level, but even with courts of appeal, where there's this big dispute over what, how far do we take a government statement and how does it factor into this decision. And I think, again, this isn't about the vaccine. This isn't about saying the government is, wrong and Health Canada is lying or anything like that. But it's just, it cannot be the case that that we defer or we kind of default to whatever the government thinks is in the best interest of the children. The government might think that a medical treatment is ideal for a child, but it really is up to that family to decide. And that's why the role of the court isn't to The court doesn't decide, is it best for the child to be vaccinated or not necessarily. They're often just looking at who is thinking about the best interest of the child, and therefore who should have the decision making to kind of move forward with that line of thinking. It's also important to note, and this is a whole other can of worms, so we probably can't get into it in detail, but there is case law that says it's what's called the mature minor doctrine. And there is case law that says that, and this came up in the context of, Jehovah's Witness children who were refusing blood transfusions, and the, doctors wanted to interject and force the children to get blood transfusions. And the Supreme Court wrestled with this question and ultimately concluded that if a mature minor, so obviously someone under the age of 18, was able to understand the medical condition they had, understand, the treatment, what it would mean to get it, what it would mean to not get it, that it could be, depending on, what the doctors conclude, maybe the courts conclude, if it gets litigated, it could be up to the child to conclude, what is in his or her best interest in terms of that specific medical procedure. And so, yeah, I certainly agree with you, Andrew. We have two individuals, parents who love their children. And I mean, the evidence on record is that they're both good parents. They both love their children. So that's not what this, feud is
and you
about.
said they've agreed on everything else about their arrangement,
Yes.
but this, yeah.
Yeah, exactly. So it really is, for us, it's not a matter of, these children absolutely shouldn't have the vaccine or not. It's just, we're really concerned that, a government statement is going to now kind of subvert the ability of a parent to have a shot at kind of making their case to a court about what's in the best interest of their children. And I don't think anyone intended for government statements from Health Canada about a vaccine being approved to kind of subvert the ability of a parent to act in the best interest of their child. So that's what I would say this case is ultimately about. And I think if this gets appealed to the Supreme Court, if we get leave to appeal, I think it would be precedent setting for sure.
You've got a website set up. Explain why that is.
Yeah, so I mentioned, I think at one point that we jumped in at the later stage. So the mother has been self-represented for at the trial level and at the Ontario Court of Appeal, and that's kind of a separate concern. We're worried that in light of her having 6 kids and her resources having been depleted over 8 years of messy litigation, that there was just no way for her to make the strongest case she could, not just for her interest, but also for the preferences and views of her 2 children. And so we jumped in and we're helping with, this latter stage of litigation, but her resources are still depleted. And so we have a fundraising page set up for her to kind of get some support. This case has national ramifications if it goes to the Supreme Court. So it really is not just about her, but it's about kind of families across the country and their ability to act in the best interest of their children. And so you can go to helpamom.ca. That's all one word, helpamom.ca, and make a donation there. You can also get some additional information for those who are really interested. And we didn't have time to cover all the details. So if you're curious, you can go there for more information and to help out a mom.
Lia Milousis from the Acacia Group. That website again, helpamom.ca. We did talk about this case in its earlier iterations, so I'm glad that she has an advocate in this as to those children. Thank you very much, Lia.
Thanks so much, Andrew.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.